Members of the jury, you've now heard all the evidence and the argument of the counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments. 1, life imprisonment without the possibility of parole, or 2, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are as follows. Please note that the following aggravating factors apply to both counts 1 and 2 unless otherwise noted. 1. Johnathan Quiles was previously convicted of another capital felony or a felony involving the use of threat of violence to another person. First-degree murder is a capital felony. The crime of sexual battery is a felony involving the use or threat of violence to another person. 2. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3. The first-degree murder was especially heinous, atrocious, or cruel. This applies only to count 1. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to IS. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner, without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. 5. The unborn child of IS was a person less than 12 years of age. This applies only to count 2. 6. IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. This applies to count 1. The unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS. This applies to count 2. The state has the burden of proving an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, in conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided with a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must next determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are as follows. 1. Johnathan Quiles has no significant history of prior criminal activity. 2. Johnathan Quiles' age at the time of the crime. 3. Johnathan Quiles was raised by his mother while his father was absent from his life. 4. Johnathan Quiles was 33 years old at the time of the offense. 5. Johnathan Quiles began using marijuana at the age of 12. 6. Johnathan Quiles lived with his mother, but she was never present in his life and always worked. 7. Johnathan Quiles' mother's boyfriend abused him. 8. Johnathan Quiles was forced to drop out of school at a young age to take care of his child. 9. Johnathan Quiles went to drug rehab at the age of 15. 10. Johnathan Quiles began to work at age 15 to care for and contribute to his family and was unable to finish school. 11. There were no men in Mr. Quiles' mother's life on a regular basis. She had short relationships with men and her boyfriend abused him. 12. Johnathan Quiles' brother regularly bullied him. 13. Johnathan Quiles' mother is deceased and his only relatable family is his aunt and cousin. 14. Johnathan Quiles was raised by his mother in a high crime area. 15. Johnathan Quiles fathered a child at the age of 15 and had to work to provide for his child. 16. Johnathan Quiles had a poor relationship with his father and he was absent from his life. 17. Johnathan Quiles' father was absent from his life and his mother used corporal punishment. 18. Johnathan Quiles' IQ test is above average intelligence despite dropping out of school at a young age. 19. Johnathan Quiles does not have any known cognitive or neuropsychological deficits. 20. Johnathan Quiles has a history of alcohol and cannabis abuse. 21. Johnathan Quiles has a dysfunctional family background. 22. Johnathan Quiles has one brother. 23. Johnathan Quiles has a close relationship with his aunt and cousin. 24. Johnathan Quiles has a loving relationship with his 5 children. 25. After Johnathan Quiles dropped out of school, he had to take care of himself and his children. While his mother lent support, he had to take care of responsibilities causing him to leave the family home. 26. Johnathan Quiles was a hard and dedicated worker. 27. Johnathan Quiles has no disciplinary reports while in jail since his arrest. 28. Johnathan Quiles worked as a trustee in the jail. The final step in the process is for each of you to determine whether the defendant should be sentenced to life without the possibility of parole or death. In making your decision about whether the defendant should be sentenced to life without the possibility of parole or death, you must weigh the following factors. 1, whether sufficient aggravating factors exist. And 2, whether the proven aggravating factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote to the death penalty, your recommendation must be for life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. You will be provided with a form to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. When considering the aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. The case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your decisions should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. The verdict must be in writing, and for your convenience, the necessary forms have been prepared for you. They are as follows. There's 2 forms. Each form is 3 pages, one form for count 1, one form for count 3. It's slightly different than the last one you had last week, but although very similar. The one I'm holding right now is one for count 1. As you can see at the top, it has the aggravating factors, and it goes through each aggravating factor for that count alleged by the state. And it says, we the jury unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Johnathan Quiles, in this case. And then you go down each aggravating factor and you check yes or no. That has to be a unanimous decision by all 12 of you on the jury panel. And remember, there's 5 per count, 6 total. If you check, and then on the next page, it tells you if you, the jury, answered no to every aggravating factor listed, you've completed your deliberations. The foreperson should sign and date the form at the end of the form. If you, the jury, answered yes to any aggravating factor listed, then you go to section B, which is on page 3. And section B is on the last page. It goes through the instructions that you are supposed to go through, that weighing process that was talked about. And then at the very bottom, it tells you how to return your verdict in that regard. And then the foreperson signs and dates it. And that's the same process for count 2 as well. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about this case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through telephone, writing, electronic communication, blogging, Twitter, email, texting, etc. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, other devices here in the courtroom. The rules do not allow you to bring those phones or devices with you into the jury room. Mr. Gray will take custody of them just like last week, and you'll be given back to them at the conclusion of your deliberations or if we break for the day and come back tomorrow. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in that note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So, fortunately, we had all 16 of you for the past 11 days. Do the 4 alternates from last week, do you guys have any personal effects in the jury room? Okay, well, Mr. Gray will take you there to get your personal effects. I'll bring you back in here, and then I'll dismiss the other 12 to the jury room. guys, why don't you guys hang over here to my left, your right. So, members of the panel, just like last week on Thursday, it's about 4:20. We'll be here until you guys tell us otherwise. If you guys want to break for the day and come back tomorrow morning, that's perfectly fine. Just let us know, and we'll bring you back tomorrow morning when you guys let us know you want to break for the day. If you guys want us to order you dinner by a certain point, let us know. We can certainly accommodate that as well. We need to know by 6 if that's your preference. If you don't want to break for the day and you want to go for a couple more hours, it's up to you. There is no rush. You take whatever time you guys need. We will wait to hear from you as to what you want us to do in that regard. We will be here as long as you want. And if you want to break or order dinner, we will do that. And if you want to break, we'll come back tomorrow morning and just continue your deliberations. It's up to you guys. You can let Mr. Gray know immediately, or you can wait a while and slip him a note. And we can go from there. And I'll let the attorneys know what your preference is in that regard as to how we move forward. But until then, all the evidence and the instructions will be provided to you in the jury room. And we will wait to hear back from you guys. You guys may have a seat. So to the 4 of you, this officially ends your jury service with us. You are officially dismissed. I'm sorry we had to bring you back, not knowing. You just never know what's going to happen with a member of the jury, so we wanted to make every effort. We brought this to a conclusion this week. Even though you couldn't serve and be in the deliberation room, please don't think that your service is any less that we are less grateful for your service. It is to be here for 11 days is a monumental task. To be away from your family and friends, your work, personal lives, essentially put it on pause 2.5 weeks ago, is a monumental task. I am fully aware that when you got that summons in the mail about 2 months ago now, and when you came here that Monday morning, this is not what you thought your life would go for in September. I am extremely grateful for your service. We can't do our jobs in this courthouse without people like you willing to serve and step up. And I gave this what I thought was a profound speech a couple weeks ago regarding jury service and what it means. I am incredibly grateful for your service. But with that said, I'm sure you don't want to hear me talk anymore. You guys are officially dismissed. I feel like I know you guys already, but I don't know you at all. So you guys have a good day. Just so you guys know, the cameras never showed you guys. No one knows your identity. That's why I use juror numbers. That's my practice. And so just feel some solace in that. That said, you guys, security walk you guys out, and you guys are free to go. All right, so the jury is officially outside our presence. I wanted to make a couple grammatical changes to the jury instructions. I read it as if the grammatical changes were fixed, but I want to give them a clean copy. So other than that, is there any exception or objection to the instructions as read to the jury from the state?
Your Honor.
Defense.
Judge, we raise our previous objections that we had stated before, having to do with elevators and
The familiar or custodial issue?
yes, sir, Your Honor.
Okay. Anything else?
No, sir, Your Honor.
Okay, well, we'll be in recess. I'll fix this up. I'll sign them and get them off to the jury panel, and we'll just notify you guys when we hear something. So we'll be in recess.